because I want to welcome everyone to the final session of the day, at least for me. And I hope that you guys have been enjoying this conference. TJ Hill is amazing. I'm very excited about his session on supervising employees with disabilities, best practices, reasonable accommodations, and the interactive process. A very important topic, and TJ has a very long bio, and so I might let you, TJ, explain who you are so I don't take up too much time with everyone, because it's pretty extensive. You can just explain your background. And then if you have any questions, you can DM me. My name is Cynthia Lieberman, and I'll put my information in the chat room. And also, please mute yourself. And at the end, we'll have an evaluation form, which I'll put into the chat room. But in the meantime, I'm going to let TJ take it away.
Great. Thank you so much. So hello, everyone. My name is TJ Hill. Just for those that need the cue, I am a white male with a dark, short beard and kind of messy blondish brown hair, devastatingly handsome, and I'm wearing a plain blue shirt. So the background, my background is pretty simple. Oh, and I go by pronouns he and his, just so everyone knows. The biggest thing that's important is I am the executive director of the Disability Community Resource Center. And that is an independent living center in Southern California, here in Mar Vista. And we employ over 98% of our staff are people with disabilities, myself included. And that has given me a very different perspective on sort of the traditional roles that I've had as an attorney working on labor issues and things. I've thought a little bit more deeply about best practices and sort of how we do stuff. So I'm going to cover today a lot of the regulations in the law, but I really want to sort of put that within the context of framing it is as employing people with disabilities, because too often on the employment side, what we see is that the reasonable accommodation process is actually used as a way to sort of weed employees out of the employment sector. And my goal and my orientation of that is completely opposite. So hopefully that will frame stuff and we'll have a good discussion today. So I'm going to try to do this share the screen thing. Let's see, it will let me. All right, it's not letting me. Oh wait, share, let's see. All right, can you all see what looks like a screen?
There you go.
Yes.
It looks great. Looks great.
Perfect. Great. So today I'm going to be talking about supervising employees with disabilities, best practices, reasonable accommodation, and the interactive process. So a lot of this is going to cover the law, but I'll just kind of stop in between and hopefully tell some anecdotal stories. And then at the end, I hope that we will have enough time for questions. But overview of today, under the Americans with Disabilities Act, an employer has ongoing obligations with respect to managing an employee with a disability. As a general rule, employers may not take any action that negatively affects the employee's terms, conditions, or privileges of employment. Examples are demotion, reassignment to a less desirable job, failure to promote, or termination, if the decision is based on disability. This includes treating an employee with a disability differently from employees without disabilities by applying workplace policies inequitably. Managing an employee with a disability may also involve providing a reasonable accommodation and understanding how to deal with the employee's performance issues. So that's what we're going to cover today as a total overview. So the basis for it. The federal law is the Americans with Disabilities Act, which has 5 titles. The Americans with Disabilities Act was signed into law in 1990 by President George Walker Bush. And this was not only probably the most bipartisan civil rights legislation that ever has been passed by Congress, but it is also the most comprehensive. It covers all aspects of community life, both interacting with the government in private places, but also in necessarily employment. So employment is covered under Title I. It protects qualified individuals with disabilities who, with or without a reasonable accommodation, can perform the essential functions of the job. So that Title I covers all aspects of employment, the job application procedures, hiring, termination, training, pay, promotion, benefits, and leaves of absences. The ADA definition of disability is a physical or mental impairment that substantially limits one or more of the major life activities of such an individual. A record of such an impairment or regarded as having such an impairment, which is also really important for employers to think about. If oftentimes there's an assumption that somebody might have a disability, and if that person is being treated differently on that basis, regardless or not if the employer or others are correct in their assessment of that person's disability, they are technically covered under the ADA. Major life activities include, but are not limited to, caring for oneself, performing manual tasks, seeing, hearing, eating, sleeping, walking, standing, lifting, bending, speaking, breathing, learning, reading, concentrating, focusing, thinking, communicating, and working. The operation of a major bodily function includes, but not limited to, functions of the immune system, normal cell growth, digestive, bowel, bladder, neurological, brain, respiratory, circulatory, endocrine, and reproductive functions. So who's covered under the ADA? It's important for a supervisor to realize that a physical or mental impairment is not always obvious. And this is particularly true for what we call in the disability community, hidden disabilities, such as lupus or depression. And that an employee need not have an actual disability, that's what we were talking about as regarded as, in order to be covered by the ADA. For example, an employer with a record of having an impairment could be fully recovered, or an employee regarded as having an impairment could be erroneously treated as having a disability. However, it is also important for supervisors to realize that an employer's focus should not be on evaluating whether an employee is considered disabled under the law. Rather, the focus should be on whether the employer has complied with the accommodations obligations under the ADA. And this is the most important one for me. Obviously, in our center, I mentioned that the majority of our employees are people with disabilities. That's a very unique workplace, and I know not typical of the rest of the world, but it does directly relate to that peer-to-peer model. What I've always sort of assumed in our culture is that that I have an obligation to accommodate somebody, and that there likely could be a disability. And by putting that orientation, it not only protects the employer legally from the onset, but it also creates a different sort of mindset for the interactive process, which we'll talk about. So the first part of maintaining this sort of culture of acceptance is make sure that you're drafting and maintaining accurate job descriptions. This is sounds really like basic and kind of maybe counterintuitive to people, but this is actually where employers start to get in trouble when they're having issues with complying with the ADA. So an employer should draft accurate job descriptions that set forth the most important duties or tasks, i.e. the essential functions of each job, and review, update job descriptions regularly. Understanding what is covered as considered an essential job function is important because the ADA protects individuals with disabilities who can perform essential job functions with or without a reasonable accommodation. A supervisor, along with management and HR, should be familiar with these job descriptions so that when an accommodation request is made, he or she can discuss the employee's ability to perform the essential functions of that job and determine which accommodation would be reasonable and effective. The supervisor should understand that not every function of an employee's job is essential. Essential functions are those that are fundamental to the position, not those that are merely marginal. So we'll talk a little bit about sort of what that test is. So factors to consider when determining whether a function is essential include the employer's or supervisor's judgment. So, thinking about what are those basic things that I'm really asking for this position. The amount of time the employee spends performing that particular job function. For instance, a clerical position, one of the biggest mistakes I see people put there is they say typing. Typing is an essential function of a clerical job. And when you really look at it, the actual the function of typing isn't necessarily, it might be note taking, it might be transcription, it could be other things that don't actually require typing on a keyboard. And so that's a common mistake, and like you'll see that in a lot of clerical jobs. We used to see it a lot of like how many words per minute somebody can type. Those things really get you in trouble because that's probably not an essential function in itself of the job. The consequences, if the function is not performed, that's one of the factors to think about. A collective bargaining agreement, that's usually always going to supersede you if you have one of those in place. And the work experience of present or former employees in the particular job or in similar positions. So again, thinking about, well, is this something that all people on this classification of job do? That will help you sort of determine if it's an essential function. So when you've got your job description, you've got an employee, what do? So fielding accommodations requests. A supervisor must know how to recognize an accommodation request, which is a request by an employee for a change in policy or other assistance that relates to the employee's employment because of his or her medical condition. An employee's request for an accommodation may be made at any time, can be written or verbal, and does not need to use any legal words such as reasonable accommodation or ADA. In addition, an individual other than the employee with a disability may make the request for accommodation on behalf of that employee. That can include a coworker, a supervisor. It can also include outside parties. One thing that I always highlight in this section is, does anyone have an idea of what do you do if the disability is very obvious? Does that person necessarily have to request an accommodation? The answer is no, and that's a big one for folks. Corporate employers get in trouble with that all the time because HR folks are really afraid to ask about disability, and we'll talk about that why. But if a disability is very obvious in your face, like an employee wheels into your office and appears to have disabilities that will need accommodating, it's really on the employer to start that interactive process. So whether or not the employee formally requests an accommodation, to figure out how that employee is going to do your job, the employer, by being visually put on notice, is on notice. So that's something to pay attention to, and that particularly is true in California. I'm not sure if that's true across all 9 circuits, but it has been something that has been an issue here in California. And again, is best practice. A supervisor should generally not handle accommodation requests on his or her own. Most employers require accommodation requests to be referred to HR or another department designated to handle such requests. In my center, because we're a relatively small shop, all those requests come through me, and I evaluate them with the manager of that employee. At the very least, a supervisor should seek guidance from HR or other relevant department. The supervisor's familiarity with the employer's procedures is critical, since many employees will approach their supervisors first when they experience job difficulties. So that brings us to engaging in the interactive process. Accommodation requests must be evaluated on a case-by-case basis. Therefore, when an employee requests an accommodation, the employer must engage in an interactive process, which is a two-way communication between the employer and the employee to determine whether a reasonable accommodation exists. The interactive process will help identify the employee's precise limitations resulting from the disability and the potential accommodations that could overcome those limitations. Only reasonable accommodations must be provided. An accommodation is not reasonable if it creates an undue hardship, a significant difficulty or expense for the employer. The supervisor must take care in discussing the accommodation request with the employee. For example, the supervisor should not tell an employee that the accommodation request is denied prior to the request being fully evaluated. That's, again, another one of those areas where folks fall into making a mistake, is just assuming, for instance, that the accommodation is going to be too expensive. And we'll talk about sort of that test. But very rarely can you just, and I would say actually never, when an accommodation request has been made, just flat out deny that request without a full evaluation. And we'll talk about why. This is where I like to always emphasize, the goal here is employment, right? That's what we want. We want people with disabilities to be employed. So when you're looking at when you're going through this evaluation of reasonable accommodation and undue hardship, you really want to think about the goal is to harness that talent in the community and to have employment for that individual. Reasonable accommodation is readily accessible and usable by people with disabilities. So it can't be an unreasonable accommodation is sort of what that's saying. Examples that are simple reasonable accommodations are job restructuring, modified work schedules, reassignment to open position, acquisition or modification of specialized equipment, appropriate adjustment or modification of exams, training or policies, provision of qualified interpreters, or other similar accommodations. The ADA and all of this interactive process and is also enforced by the EEOC. So that's just important to keep in mind. An undue hardship is an action requiring significant difficulty or expense when considering the nature and cost of the accommodation and the overall financial resources of the facility involved in providing the reasonable accommodation. So this is also a test where employers have historically messed up, right? When you're looking at whether or not it's an undue hardship, you're looking at the total operational budget of that organization. So there was a famous case many years ago of a tech company. It was a very large tech company, but they had a small regional office, and the employee was requesting some pretty significant and costly accommodations. And the employer tried to say, well, no, in the small little regional office, we don't have that in our budget. However, the large parent company, they definitely had it in their budget. And so when that employee sued the employer for failure to provide a reasonable accommodation by using this undue hardship test, they lost in court because they found that no, there was a lot more resources there. And that's generally true even if you're a small employer, they're going to look at all the resources. So even though you might be a small nonprofit, if you are a several $1 million operation or just $1 million operation, they're going to look at that total $1 million in terms of, do you have the resources to be able to provide the accommodation? That being said, it's an interactive process and you don't always have to go for the most expensive accommodation. Again, the goal is to make sure that it's readily accessible and usable by the person with a disability. So things to keep in mind. Did you know that the interactive process does not just end because an employee's initial accommodation request is unreasonable? If this occurs, the employer must explore alternative accommodation options. So this is sort of the most important part of the interactive process is that, again, I might have an employee who comes in, who is deaf and requires a certified interpreter for all their interactions at work. Does that mean that if the employer comes, that I have to hire an entirely different staff person to be that full-time interpreter for the employee? And the answer is no, not necessarily. If I can find other means to provide that effective communication for that employee, that might include, limited video interpreting for meetings or live interpretation for some like important meetings where there's a lot of interaction, and then using other means of communication, either through email or text messages or things that provide effective communication in the workplace, that might meet my obligations. But again, it's a process to go through that, and even looking at the type of accommodations available. As long as you're meeting that effective communications, you can evaluate different services and contractors and look to see, am I really getting the best deal for my money for this accommodation, in the case of something that might be very, very costly. So it is this, that even if you come out with something that is initially seems very costly and is not doable, you do have an obligation to go back and explore, are there alternatives that we can use that would still provide for that reasonable accommodation. It's an ongoing process. The employer does not need to provide the exact accommodation that the employer requests. That's what I just spoke about, as long as it provides an accommodation that is that effectively allows the employee to perform the essential job function duties. The duty to accommodate does not end once the employer provides the employee with an accommodation. And on an ongoing basis, the employer must make sure that the employee's accommodation continues to be effective. The supervisor is in the best position to monitor the employee's progress with the accommodation and evaluate whether the accommodation needs to be adjusted or replaced with another. Making disability inquiries. This is another area where employers really get hung up on. And I spoke about that case where a disability is very apparent. Again, obviously that allows you to have some discussion with the employee. But the ADA generally prohibits employers from asking an employee questions that are likely to elicit information about a disability. Therefore, unless there is a legitimate business reason, such as when an employee requests an accommodation, a supervisor should not ask an employee whether he or she has a disability, how he or she became disabled, about the nature or severity of the disability, or whether he or she is taking prescription medication. Disability-related questions may be asked when they are job-related and consistent with the business necessity. The employer has a need to know information about the disability in order to determine what will be an effective accommodation. So again, if an employee presents themselves with a very obvious disability and they mention, I might need some modifications to my job, they don't have to use ADA or reasonable accommodation, but they're talking in that way, then you can go into some questions about their disability inquiry. But generally, you can't use it, particularly upfront, in any kind of way to screen out employees. And that's unfortunately what we do see a lot of employers doing. I'm just making sure that. Okay, sorry, I just saw a few comments in the chat. Thank you very much. Managing performance. While the ADA prohibits an employer from discriminating against employees with disabilities, the ADA does not prevent an employer from managing an employee with a disability who has performance issues. If the performance issue is unrelated to the disability, a supervisor should treat the employee like any other employee. So this is one that folks get really hung up on. They think like, well, can I reprimand an employee who has a disability? And the answer is yes, you can if there's a performance issue. But if it's related directly to their disability, then you have to go through that evaluation about reasonable accommodation. If the disability does affect performance, a supervisor must remember that employer need not lower performance standards for employees with disabilities. However, the employer may need to provide a reasonable accommodation that helps the employee meet such standards. An employee need not ask for an accommodation in order to be eligible for one. We've reviewed that before. A supervisor may proceed with a disciplinary decision, including termination or poor performance evaluation, if there was no prior notice of the disability or need for accommodation. Having documentation that that discipline decision or poor performance was made prior to the employee revealing his or her disability will go a long way toward defending against ADA claim. So this section came from a labor attorney who represents employers against claims of discrimination. I always hope to never be in that position, right? Again, if you have an open policy of reasonable accommodation, you make that known to the employees, particularly in the beginning of the hiring process. And it's an ongoing sort of culture of, we provide accommodations for people. Not only are you going to get more applicants with disabilities because people tend to want to work places where they feel welcome, but you're also going to have a much better process when you do have to go through disciplinary action, if you have to do that. Because you get to balance this, is the performance issue related to the disability and accommodation? Do I need to modify that accommodation, or is it a true performance issue? And either way, you're going through the process of documenting both. Preventing discrimination and retaliation. So it goes without saying that a supervisor must not discriminate or retaliate against an employee based on his or her disability. However, supervisors must also prevent others from discriminating or retaliating against employees with disabilities. Failure to prevent or remedy discrimination, including harassment, could lead to liability under the ADA. For an example, an employee who makes a derogatory remark about another employee's disability must be told to stop. The supervisor should follow the employer's harassment and discipline policies as needed. A supervisor should also keep an eye out for retaliation against an employee who complains about discrimination or requests accommodation. I'm going to give an anecdotal example there. I was working with an employer, they were not my employer, but I was working with an employer who in a staff meeting, before the staff meeting, sort of that social time where everyone's like having a donut and coffee, one employee made a very derogatory joke about mental illness that wasn't just generally about mental illness, but particularly about one of the employees who was had told people that they had taken a leave previously for a mental health disability. And the employer who was heading that staff meeting, because it was during that social hour, thought it was awkward to sort of interrupt it. And so they just started the meeting and we're like, okay, let's focus now and we're going to start our meeting. And they never addressed it. That employee who had the mental health disability and had taken a leave of absence and had gone through accommodation procedure with the employer, and the employer had done all of those things and complied with the law, that employee sued the employer for failing to step in that moment, and they felt like they were in a hostile work environment, and they succeeded in that action. So it's really important to also look at discrimination and retaliation across the organization. So documentation. A supervisor must have good documentation to show that his or her decisions were based on non-discriminatory and non-retaliatory business reasons. Documentation should include performance issues observed, conversations with an employee regarding the issue, and any other steps taken to remedy the issue. Formal performance evaluations, those are always great. complaints of discrimination, harassment, or retaliation, and steps taken in response. This is the most under-documented thing, and I think it's because employers are afraid to document where somebody has raised that issue of discrimination or harassment. That's the biggest mistake you can make as an employer. Make sure that you document that somebody reported that, and then whatever steps you took to address it formally. Accommodations requested and accommodation options explored. That's always very important to document. The decision-making process, including the accommodation that was chosen and why, and accommodations that were not chosen and why. And so that can be very straightforward, but it is good to at least say, these were all the options we looked at, and this was the one we chose. And the reason we chose it was because it met these criteria, sort of the best fit for us. Any effort made to modify an accommodation if necessary. Again, this is an ongoing process. Disability changes over the lifespan, the needs change in the workplace. It's important to keep on evaluating the accommodations, seeing if you need to make a modification. And if you do make a modification, make sure that you document that. Confidential medical information. So this comes up a lot, and this is a big red flag that I always raise with employers in my various roles. Employer must keep employees' medical information confidential. For example, supervisor is prohibited from disclosing an employee's medical condition to the employee's coworkers who are asking about why an employee is receiving an accommodation. The supervisor should make clear that to the coworkers that confidentiality requirements apply to all employees. The employer must also protect the confidentiality of employees' medical records. Medical records should be maintained in a file separate from the employee's personnel file. Access to the employee's medical file should be limited to certain individuals, such as the employee, HR personnel, the supervisor responsible for complying with the ADA and working with that accommodation, any medical staff that you would have, or safety personnel. Those are the only folks that should be able to see those medical records. This came up recently with COVID-19, and I know a lot of employers are sort of dealing with this. If you have a vaccination requirement and you ask for verification of that vaccination for your employees. And then I saw this with a lot of my sister ILs, and I quickly was like, whoa, guys, don't do that, right? People were like, oh, okay, so we're gonna get verification that they've been vaccinated. And they put that in their employee record. Like, they're like, that's the best way to keep it, is just to put it in their employee record. And that's the absolute worst place to put it. And what I actually told people is, you don't have to actually keep the actual record unless you really, really want to. No one's gonna ask you for that actual record, as long as you verified that. So you can designate one staff person to say, just show me the vaccination record, and they can make a note of it, and then keep that separate, with from all the other personnel records. But that's a common mistake that people make. And so you want to make sure that all of that, any kind of medical records, are kept separate from the personnel file. So we're going to move on to some testing ourselves, interactive part. So that's pretty much the end of my whole presentation, and I want to open it up for questions and anecdotes. But so first question is, Jack operates a crane and has been out of work for 6 weeks because he had surgery on his shoulder. Jack's employer asks that he have a medical examination and bring in a doctor's note saying he is able to return to work. Jack objects, saying he does not want to go back to the doctor for yet another visit. Must Jack comply with the request? And the answers possible are A, no, Jack does not have to establish he is fit to return to work because his employer should take Jack's word that his shoulder injury has healed. B, yes, Jack must comply with his employer's request because the request is job related and consistent with business necessity. C, yes, Jack must comply with the request, as Jack's employer asks all employees who have suffered an injury to establish that they are fit for duty to ensure the safety of the crane operations. and then D is both B and C. So what are folks?
I say, do you want to just put it in the chat room? Everybody can just answer in the chat room.
Yeah, put it in the chat.
Do we have enough information to answer this? Do we know what Jack's employer asks of all of their employees? I don't.
That's a good question. You're asking the right question. I can say that.
Okay.
So I'll go ahead and answer it. I don't see anything coming up in the chat, but the answer here is D. It's both B and C. So Jack must comply with this because he's operating a crane, and that's an inherently dangerous thing. You want to make sure that people that are operating dangerous equipment comply. But yeah, in this case, now if they were just asking it of Jack and they weren't asking it of all their employees, then no, C wouldn't apply. But in this case, we can assume that the employer is because being a crane operator is inherently dangerous, and you want to make sure that that person has the full use of their shoulder, and their arm to operate the crane. That this request would be sufficient, and that it would be something that they were asking of all the employees that returning from an injury leave. All right, oops, now it's not letting me advance. This is what happens when I open the chat. Let me see. Yeah. Nope. There we go. Anna has a hearing impairment. Actually, now my screen is blocked. Can someone else read that out loud?
Here,
I'll read it.
read it. Oh, go for it. Yeah, Sarah, please.
Go ahead, Felicity.
Hi, I'm actually Cynthia Lieberman. You go ahead, Sarah. I think you should read it.
Anna has a hearing impairment and misses several assignments given during meetings with many employees in attendance. At the beginning of each meeting, Anna tells her supervisor that she has trouble hearing in large groups due to her hearing impairment and asks her supervisor to speak louder so Anna can hear better. Anna's supervisor does not. As a result, Anna misses several deadlines and is disciplined for poor performance. Should Anna's employer have disciplined her? A, yes, Anna failed to meet her deadlines, an essential part of her job duties. B, no, Anna's supervisor was on notice of Anna's hearing impairment and need for accommodation. Oops, and then it disappeared. Oh, C, Anna did not use the words reasonable accommodation, so her employer was not put on notice that Anna needed an accommodation to perform her job duties.
We're getting B's, and B is the correct answer. So the supervisor was aware that Anna's hearing impairment affected her job performance. So the employer was on notice that Anna had a need for reasonable accommodation. So B is the correct answer, and it looks like most folks got that. And she had very clearly said, in those meetings, like, I'm having trouble hearing. But although this seems like a really easy one, this is one that employers get wrong all the time, and they assume like the person in the actual moment says, I'm having difficulty with this, and again, they don't have to use the words reasonable accommodation or ADA or anything, but they're saying, I'm having difficulty with this part of the job, and then later the employer comes back and says, hey, you weren't performing this part of your job, and goes for a disciplinary action. So people make this mistake all the time, but good job everyone on this. All right, the next one, and I'm trying to get why I can't twist this away, but all right, can someone read my chat is blocking my entire middle of my screen, so that's why I'm not able to see it. I know it's Tyrone. Who wants to read this one? Come on, someone in the audience, join in. No? Okay.
I gotcha. Hold on.
Computer dropped out there.
Tyrone goes to dialysis 3 times a week. He goes as early in the morning as possible, but needs to arrive to work an hour late. His coworkers ask their supervisor why Tyrone is allowed to come in late on a regular basis. How should the supervisor respond? A, the supervisor should ask the other employees to show some compassion because Tyrone is going to dialysis due to kidney failure. B, the supervisor should ignore their questions because Tyrone's business is none of their business. C, the supervisor should explain Tyrone's situation because his coworkers have a legitimate need to know. D, the supervisor should explain the employee's obligation to maintain the confidentiality of Tyrone's and all other employees' personal issues.
All right, and in the chat, we're seeing lots of D's, and that's awesome. You guys got it right, because D is the correct answer. The supervisor is obligated by the ADA to keep the employee's medical information confidential, and therefore, choice A and C are incorrect. The other employers did not have a legitimate need to know about, employees do not have the legitimate reason to need to know why about Tyrone's medical condition. Ignoring employees' choice, B, is not proper or effective way to manage employees. So D is the best answer here. Great job, everyone. All right, so this is the part that I really enjoy because I know that I specifically made this presentation so that there'd be questions, and I can share a little bit of sort of what do I do in the moment answers, because a lot of this is sort of seems very technical, but a lot of it is actually just sort of good business sense, but maybe doesn't come intuitively to everybody. So questions, comments, thoughts, and feedback. Yes, I see a hand up.
Okay. I have, so it seems to me that that like there's imagination required, and that sometimes it seems to me that sometimes people like might, particularly in the area, like when we're talking about mental health related disabilities, there are probably accommodations that would be helpful to people that they haven't even thought of. And so I just wonder, can you talk about some of the like great accommodations in the area of mental health that people don't think of often?
Yeah, so mental health is one of those ones that people think are like, well, just I will say all disabilities, or for some reason employers are very afraid of, generally seem very afraid of accommodations in the workplace. And it creates sort of this hostile environment where then the employees don't feel like that you know, that maybe they should ask for an accommodation. And that's why you get into situations where employees that, you know, are subject to some sort of performance review and then all of a sudden reveal that they have a disability. That is particularly true in the mental health space. So I really like to begin in the beginning of the employer process, right, to talk about the kind of accommodations that we provide. And the most simple one for mental health disabilities is modified work schedule. I've had this with many employees of mine in the past who have behavioral health needs. And it can be everything from they have you know, to see a clinician a couple times a week. That's during the work schedule week. And so, you know, can we do a modified work schedule so they can go in the middle of the day to a clinician appointment? It can also be, and a really common one that I've had before, and to me, it's very like just makes sense. I had an employee who had switched psychiatric medications, and had to take their medications in the morning, right, when they got up in the morning. And the medications made them really, really, really tired in the morning. So they came into work and they were falling asleep at their desks for the first like couple hours of work. They weren't working, and obviously, you know, that was not going to work. So you know, when I approached this employee about, you know, is there a modification in this case of a accommodation, the simple solution was, well, okay, do you need to start your day later? Like, you can start later and work later if that's gonna you know, if the disability and then taking the medication is causing this you know, excessive sleep in the morning. So everyone starts at 8:30, you start at 9:30 or 10. You know, whatever you need that extra time, and then your day will be extended longer. So that's a really, really simple accommodation that I've done in the past. There are a lot of those that mental health disabilities, I think, tend to work really nicely around sort of flexible and modified work schedules. And we saw that a lot with COVID, obviously, with people doing telework. And now that's sort of become more standard, right? Like, here we are on a Zoom conference. This technology has allowed us a lot more sort of modality, I think, to have more flexible and modified work for folks.
Hey.
Hi.
Sorry about that. I wanted to mention, are we, now that you have your questions, comments, thoughts, and feedback? Oh, my camera's not on. Hold on a second. There we go. I've been listening and watching, but I just didn't have my camera going. Thank you so much, everybody, for being here. Yes, it was very organized, as Anastasia says, and informative. And it's all right there. And I was wondering if you could put a PDF